How to get a judge to drop a no contact order in California. Generally, in domestic violence cases, particularly, a no contact order is issued in almost every case. The police, when arresting somebody in a domestic violence case, will almost always issue an emergency protective order, which expires after a certain period of time, at which point the case is usually filed and the DA will ask the judge to impose a no contact or stay away order. This order usually states that you cannot contact the alleged victim in any way. You can't text them, you can't email them, you can't call them, you can't have a friend call them to relay a message, and you usually have to stay 100 yards away from that person. And yes, this often means that you may have to move out of your house and you may not have access to your children, your belongings. We can talk about that in a minute. But the main question is, how do we get this no contact order removed? So, as the victim or the alleged victim in a situation where there is a no contact order, you will have to appear in court. So, this would require, at least in Orange County, for you to arrive at the clerk's office no later than 10 o'clock in the morning and tell them that you want to see the judge to have a protective order or a no contact order removed. The judge or the clerk's office will send the case up to the courtroom, and you can have a conversation with the judge. You can certainly have an attorney appear with you or for you. It is generally best if you are there because the judge always wants to speak with alleged victims about the consequences of lifting a no contact order. In some cases, a judge will modify the order so that it becomes a peaceful contact order or a no violent contact order, which means that you can talk, you can email, text, you can live in the same house, but if any violence occurs, that would be a violation of the court order and the person could be returned to custody for that violation. So, how do we do it? You show up for court, again, you ask the clerk to send it up to the judge, and the judge will talk to you about the circumstances. Now, when you go in to see the court as the alleged victim, you're not going to say, I need him home, I can't pay the bills, I need help with the kids, because that's not going to move the judge. There are so many people that are in that situation. What you want to express to the judge is that you know how to take care of yourself, that you are not concerned about this person, that you have been to counseling perhaps, or that you have heard maybe from the defendant's lawyer that this person has attended AA meetings if alcohol was involved. That recently really changed the judge's mind in a case that I had where there was an incident that occurred. Everyone was drunk. The client attended a bunch of AA meetings and the judge said, well, that changes everything. If he's addressing the issue and you feel comfortable, I will let you have contact. Perhaps an anger management class. There are many anger management classes that you can attend online. Generally, it's a 10-hour anger management class that is done over a period of 10 weeks, but you can do it faster than that if you want to. And or you can say that the defendant has been attending counseling and that you know that they've addressed their issues. But most importantly, you want to express to the court that you feel comfortable, that you are not afraid of this person, that if you needed to leave the house, you had somewhere to go, and that you know how to come back into court and ask the court to reimpose the protective order. So the judge wants to know that you are a capable, confident person, that you are not just coming into court because you're afraid of the victim or because there's some financial need and you just can't survive without them. Now, as the defendant, you would need to be present for this hearing so that the judge can explain to you exactly what you can and cannot do. And the judge wants to make sure that you understand. You always want to go in with your attorney if you are the person charged in the case. And again, if you are an alleged victim, it is helpful to have an attorney, but not absolutely necessary. Now, domestic violence cases are not the only cases where there are no contact orders, but that is the most common kind of case where there is that kind of an order or a protective order, emergency protective order, temporary restraining order. They're called many different things, but in California, the effect is the same, where many times you can't go home, you can't see your loved ones. And this is certainly a situation that we want to be changed as soon as possible. So you want to contact an experienced criminal defense attorney as soon as possible. If you found this information helpful, please subscribe, and thank you for watching.